Your Honor, is that the number one answer to your question is the thing you've asked me to assume away, which is the thing Congress has actually done, which is in 42 U.S.C. 2000 C6 specifically provided a cause of action for the United States to maintain a cause of action under the Equal Protection Clause.
Can I give you examples where Congress has it? A state dissatisfied with Heller says anyone who possesses a firearm anywhere is subject to litigation by any private citizen anywhere in the country and gets $1 million bounty. No stare decisis, no nothing. How about in Obergefell imposes SB8 style liability on anyone who officiates, aids, or abets a same-sex wedding? How about dissatisfied with Lawrence versus Texas subjects a private consensual sexual conduct of which it disapproved to the exact same law as SB8? How about Griswold? The use and sale of contraception is subject to SB8 style liability. So this is not limited to abortion. That's the point that's been raised. It's limited to any law that a state thinks it's dissatisfied with.
Your Honor, I've at no point in the earlier argument or this one asserted that the extent of federal courts or federal court availability turns on the underlying right here. Quite the opposite.
So
I agree with you,
your
it
point
doesn't.
is that no matter how much a state intends to chill the exercise of a constitutional right, as the chief said, imposing $1 million liability for an act, which I think almost any sane person except a couple of billionaires might choose to resist, that does not give anyone a right to a federal forum when the state has deputized every citizen to act on its behalf.
No, Your Honor, it does not create federal jurisdiction as a consequence. I do want, however, in the spirit of the hypotheticals you're delivering, want to return to a point that Justice Barrett made at the end of my friend's previous argument. At a very minimum, to the extent that this court believes it has to somehow alter the ex parte Young fictioner, et cetera, to find a way to allow the plaintiffs in Whole Women's Health to proceed, at a minimum, the United States' case must thereby fail. The United States just conceded up here that whatever interest they had would be purely retrospective, as of course, there being some sort of ability to vindicate the rights that Whole Women's Health and other petitioners are trying to provide. They only seek a preliminary injunction, which is by definition exclusively prospective relief, and they cannot possibly maintain their action any further. It goes exactly one way. If the petitioners in Whole Women's Health have some sort of avenue of relief, then the United States must not, which makes sense given for the extraordinary cause of action that they're trying to bring here. Congress has provided the United States, certainly at times, sometimes with truly extraordinary powers, such as the power of preclearance under the Voting Rights Act, to give one extraordinary example. The United States here would want effectively a follow-on injunction for, in their words, in the event that the state of Texas changed its law or otherwise tried to, in a way of uncharitably putting it, if the state of Texas changed its law to comply with this court's law, and yet nonetheless have something like SB8. We have a term for when a state is put into a state where they have to get the federal government's approval before it makes a relevant legal change, and that's called preclearance. That's precisely the kind of injunction my friend on the other side was speaking of. So it can't possibly be the case they'd be entitled to that sort of remedy, just as a matter of course, in the event that Whole Women's Health succeeds.